Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's session I want to talk about what happens when an employee leaves without giving you the notice that you're entitled to. So let's imagine a scenario where we've got an employee, maybe they've got a 3-month notice period or a 6-month notice period that they are supposed to give the employer, and they have some restrictive covenants in their contract, so things preventing them from going to work for a competitor or from poaching customers and employees. So imagine the scenario where the employee just resigns. They're not giving you any notice. They're effectively just walking off. You've got two choices. One is to accept that they have broken the contract, and employers typically choose to just accept the fact that they stop paying the employee at that point, but they're probably not going to get much money back from that employee, probably hasn't really got any money. But there have been cases where employers have pursued the individual, where they can show there is a cost flowing from the employee's breach of contract. So maybe you have to hire in temporary cover to cover the position, and there's a cost associated with doing that. The second position that the employer might take is a slightly different and more interesting one. They might say, okay, rather than accept you've breached the contract, we're actually going to affirm that the contract still exists and write to you saying you need to come back to work and work out your notice. At the point that the employee fails to do that, the employer equally stops paying the employee, but the employer is then in a position where it can go to the court and it can say, please order the employee not to work for anyone else during that notice period. Let's try and enforce these restrictions under the contract. And that's what happened in a recent case of Sunrise Brokers and a Mr. Rogers. The employee, of course, tried to argue that because the employer wasn't paying him any longer, the employer couldn't enforce the notice period against him. The court disagreed with that, and they actually looked at how long it would take the employer to do a proper handover if the employee had handed in his notice and worked it out in the ordinary way. And they actually found that that was probably a 4-month period. So they were prepared to injunct the employee, or effectively tell him he couldn't work for the American competitor that he'd gone to work for, not only for 4 months during what would have been his notice period, but for a further 6 months under his restrictive covenants as well. So from the employer's perspective, this could be quite an effective way of preventing an employee from going to work for a competitor, or indeed setting up in competition and then taking action to steal your customers or your staff. It also illustrates really that employers do need to be mindful of the kind of what if an employee did try and do this to us. What if an employee did walk without any notice? What would the impact on us be? How long would it take us to find a replacement? How long would it take us to train up that replacement? How long would it take us to shore up all of our customers and ensure that we were in a strong position again? If you can document the answers to any of those questions in some way, maybe in board minutes or memo showing that you had given these sorts of issues some thought, if you do ever end up in that court scenario, that kind of evidence is always going to be really useful in terms of backing up what the employer will say at that point in time. If you've got any queries on today's session, please do email me. It's adenton@refreshinglawltd, all one word, .co.uk. Thank you very much.